previously. First-degree reckless homicide requires proof of one additional element, that the circumstances of Levi Acre-Kendall's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, Levi Acre-Kendall has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. As applied to this case, the effect of the law of self-defense is Levi Acre-Kendall is not guilty of any homicide offense if Levi Acre-Kendall reasonably believed that he was preventing or terminating an unlawful interference with his person, and reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. Levi Acre-Kendall is guilty of second-degree intentional homicide if Levi Acre-Kendall caused the death of Peter Kelly with the intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. Levi Acre-Kendall is guilty of first-degree reckless homicide if Levi Acre-Kendall caused the death of Peter Kelly by criminally reckless conduct, and the circumstances of the conduct showed utter disregard for human life. Levi Acre-Kendall is guilty of second-degree reckless homicide if Levi Acre-Kendall caused the death of Peter Kelly by criminally reckless conduct. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether Levi Acre-Kendall acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for second-degree intentional homicide or for first or second-degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find Levi Acre-Kendall not guilty. The facts necessary to constitute each crime will now be defined for you in greater detail. Before you may find Levi Acre-Kendall guilty of second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. 1, Levi Acre-Kendall caused the death of Peter Kelly. Cause means that Levi Acre-Kendall's act was a substantial factor in producing the death. 2, Levi Acre-Kendall acted with the intent to kill Peter Kelly. Intent to kill means that Levi Acre-Kendall had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that Levi Acre-Kendall acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from Levi Acre-Kendall's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of Levi Acre-Kendall, the state is not required to prove motive on the part of Levi Acre-Kendall in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. Levi Acre-Kendall did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. Number 3, the third element of second-degree intentional homicide requires that Levi Acre-Kendall did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any of the following. 1, that a reasonable person in the circumstances of Levi Acre-Kendall would not have believed that he was preventing or terminating an unlawful interference with his person, or 2, that a reasonable person in the circumstances of Levi Acre-Kendall would not have believed he was in danger of imminent death or great bodily harm, or 3, that a reasonable person in the circumstances of Levi Acre-Kendall would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of Levi Acre-Kendall's belief must be determined from the standpoint of Levi Acre-Kendall at the time of his acts and not from your viewpoint now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of Levi Acre-Kendall under the circumstances existing at the time of the alleged offense. If you are satisfied beyond a reasonable doubt that Levi Acre-Kendall caused the death of Peter Kelly with the intent to kill and did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Levi Acre-Kendall guilty of second-degree intentional homicide. If you are not so satisfied, you must not find Levi Acre-Kendall guilty of second-degree intentional homicide, and you should consider whether Levi Acre-Kendall is guilty of first-degree reckless homicide in violation of Section 940.02 of the Criminal Code of Wisconsin. You should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether Levi Acre-Kendall is guilty of first-degree reckless homicide. First-degree reckless homicide as defined in section 940.02 parens 1 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find Levi Acre-Kendall guilty of first-degree reckless homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. 1. Levi Acre-Kendall caused the death of Peter Kelly. Cause means that Levi Acre-Kendall's act was a substantial factor in producing the death. 2. Levi Acre-Kendall caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and Levi Acre-Kendall was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether Levi Acre-Kendall's conduct created an unreasonable risk to another. If Levi Acre-Kendall was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Levi Acre-Kendall did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the risk was unreasonable. 3. The circumstances of Levi Acre-Kendall's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors. What Levi Acre-Kendall was doing, why Levi Acre-Kendall was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of Levi Acre-Kendall's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that Levi Acre-Kendall did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of Levi Acre-Kendall's conduct showed utter disregard for human life. Consider also Levi Acre-Kendall's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time the death occurred. If you are satisfied beyond a reasonable doubt that Levi Acre-Kendall caused the death of Peter Kelly by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, you should find Levi Acre-Kendall guilty of first-degree reckless homicide. If you are not so satisfied, you must not find Levi Acre-Kendall guilty of first-degree reckless homicide, and you should consider whether the defendant is guilty of second-degree reckless homicide, which is a lesser included offense of first-degree reckless homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree reckless homicide, you should consider whether the defendant is guilty of second-degree reckless homicide. Second-degree reckless homicide, as defined in Section 940.06 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. The difference between first and second-degree reckless homicide is that the first-degree offense requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all the elements of first-degree reckless homicide were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find the defendant guilty of second-degree reckless homicide. In other words, if you are satisfied beyond a reasonable doubt that the defendant caused the death of Peter Kelly by criminally reckless conduct, you should find the defendant guilty of second-degree reckless homicide. If you are not so satisfied, you must find the defendant not guilty. You are not, in any event, to find the defendant guilty of more than one of the foregoing offenses. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. An information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside this courtroom is not evidence. You are to decide this case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to Levi Acre-Kendall's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of their evidence. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another, or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given their testimony. In determining the credibility of each witness and the weight you give their testimony, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial. The witness's conduct, appearance, and demeanor on the witness stand. The clearness or lack of clearness of the witness's recollections. The opportunity the witness had for observing and for knowing the matters the witness testified about. The reasonableness of the witness's testimony. The apparent intelligence of the witness. Bias or prejudice, if any, has been shown. Possible motives for falsifying testimony. And all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. Levi Acre-Kendall has testified in this case, and you should not discredit the testimony, his testimony, just because Levi Acre-Kendall is charged with a crime. Use the same factors to determine the credibility and weight of Levi Acre-Kendall's testimony that you use to evaluate the testimony of any other witness. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. Ordinarily, a witness may testify only about facts. However, a witness with expertise in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any expert opinion. During the trial, an expert witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. Ladies and gentlemen, if you would put down your copy of the instructions, the remainder will be read after closing arguments, and we're going to start with Mr. Steffen.
Your Honor, I apologize. May we briefly approach?
Yes.